7. Nationality of associations and endowments. Until now, for greater clearness, in order to present and refute more easily the theories elaborated upon this subject, I have reasoned, as has always been the case, in considering almost exclusively corporations. It is now time to apply to other artificial persons the ideas thus freed and the rule that proceeds from them in seeking what is the nationality of associations and endowments. The interest in the question, I have already said, is the same under this new aspect as under the preceding one. We shall see, however, that it is more limited, the territorial law having in this hypothesis a larger extent. Under this form the problem admits, at first view, of the same solutions, although its ideas may be slightly modified. The corporation, the association, can, it seems, belong logically either to the state which has recognized, authorized, incorporated them, or to the state upon whose territory they have been organized, or to the state whose founders or their administrators are themselves the subjects, or to the state to which they belong by their principal center of activity. For the reasons that have been hitherto expressed at length and which can here be used again almost without change, it is the last of these solutions that must be accepted, to the exclusion of the others, and after having combined the two alternatives of them, as I have done, in principle the association or the endowment takes, then, the nationality of the place where its organs of direction and of administration are situated. It enjoys, however, the power of adopting in its statutes the nationality of the country within whose limits it pursues its aim materially and especially, supposing, however, that its object can be located upon a territory. The reasons which have made me adopt this double criterion exist, indeed, as well in respect to associations and endowments as to corporations. It has seemed to me, in order to determine the sovereignty on which these depend, to be fitting to attach oneself to the conditions according to which their activity is exercised. If the corporation lives, acts in the sovereign domain of a state, it is to this state that it ought to belong by its subjection. Why should it not be the same with associations and endowments? The doctrine, and yet more, the different positive legislations, separate this kind of imaginary beings from the preceding one by a rule based on a very accidental character, in which the majority of writers pretend nevertheless to see an essential element, according as the aim pursued by it is or not lucrative. The imaginary being is submitted to conditions of organization of very different capacity and activity, some large and liberal, others generally strict and inspired with a mistrustful, sometimes even hostile spirit. From the social point of view which now engages us, this distinction offers but little interest, whatever may be the considerations ordinarily invoked in its support. In both of these applications the notion of judicial personality represents the same reality, that of rights exercised collectively by an ensemble of individuals, known or unknown, who take a more or less active part in the business, some participating at once in the contribution, in the administration, and in the benefits, others, for example, the dormant members, contributing and enjoying, but not administrating. Others finally. This is the case with the beneficiaries of an endowment, enjoying purely and simply. When it concerns a corporation the benefits are material and their privilege passes to the members themselves. They are on the contrary intellectual and moral when they result from an association or an endowment, and third parties profit of them, sometimes alone in the first case, always in the second. Yet again these differences, very important, practically speaking, present nothing essential. They hinder in no respect the application of the system that I have adopted in respect to corporations to the determination of the nationality of associations and endowments. At the utmost they give rise in this application to some difficulties more apparent than real, which apply both to the rules of public law generally followed, of which I have just spoken, and to the object, often ideal and universal, of judicial persons whose ultimate object is other than gain. A strong unity of action characterizes corporations whose object is purely material. They cannot change from a single center, where decisions are formed, from where impulsion goes forth, where benefits in view of distribution are centralized. This last operation, which is the raison d'etre of the corporation, capable of being accomplished only in accordance with a single and the same rule, all social establishments, whatever may be their situation and the conditions of their function, form only the parts strictly bound of a same whole, to which a single law is applicable, law which rules in all countries the constitution, the operation, the dissolution, the division, and which administers in principle the jurisdiction of the social domicile. International custom recognizes and sanctions this unity of law and jurisdiction, in a word, this social personal statute. This universal recognition is, moreover, facilitated and justified by the similarity of rules judicially imposed with respect to this subject by the different legislations which admit nearly the same types of corporations. Associations have by no means need of this unity of action and direction. The lien that binds the members and hinders the artificial person from dissolution is purely ideal. consisting simply in a community of aspirations, of beliefs, of ideas, or of tastes, manifested by a common effort. It is not altered by the diversity of groups formed according to variable material conditions by these members in view of efficiently directing their efforts in the same direction. These groups, kind of associations within the associations, can be very well ruled by different laws without ceasing to be the molecules of the same body and constituting a single association. It is thus that the conception of an association provided with as many domiciles and nationalities as it comprises groups formed in different countries is not at all contradictory. Such is the case of religious congregations, of Freemasonry, of some scientific companies. Each lodge or each convent leads a distinct judicial life, is submitted to a different personal law, although, by its rule of conduct and its actions, it may be in entire communion with the collection to which it belongs. One cannot, then, conceive in French law, in respect to artificial persons, and the other Western legislations ought, we think, to impose the same solution. The possibility of the problem which has heretofore engaged us and which I have solved in making appeal to the autonomy of the parties, that of a plurality of social seats of equal importance, from which would result for the corporation many nationalities if its founders or its representatives had not necessarily chosen one of them in an express or tacit manner. This difficulty, very embarrassing, is not raised here, as many groups, so many different nationalities. It is not more to be conceived of an association which, meeting in France, would be foreign because it would obey an impulsion which comes from abroad. This association will be considered as domestic, and ought to be conformed to the French law. Thus the public law of the state demands it upon whose territory it pursues in its domestic sphere, the aim common to all the parts of this collection, strictness motived by the disfavor that imaginary beings of non-lucrative aims inspire, as much as by the diversity of rules imposed in each country relatively to their constitution, to their function, to their capacity, to their dissolution. This diversity is known especially in respect to an endowment. French law almost entirely ignores this notion, or, rather, it modestly slips it into the realm of donations. We have left off at donations sub modo instead of giving to a church or an abbey. One gives to a commune, it would be more exact to say to a corporation. The German doctrine has arrived little by little to the notion of an independent patrimony, constituted without its being necessary that it be confounded with the patrimony of an artificial person already existing. It is the patrimony itself which becomes an artificial person. The endowment becomes a patrimony existing in view of accomplishing one aim. The learned writer could have added that in fact this conception is actually realized in France as well as in Germany. The state, observes M. Treatise, recognizes as an establishment of public utility works that do not rest upon an association, works that are constituted simply by a certain capital designed for any aim whatever, endowments in the most technical sense of the word. And he cites many examples that have since accrued. Nothing remains unless the conditions of constitution, of function, and of suppression of establishments of public utility differ seriously from those which are provided by Articles 80-89 of the German Civil Code. That which M. Sales of the German Stiftung says is better yet applied to the English trust or the Mussulman waqf. These are, in all the meaning of the term, endowments which enjoy an independent personality, in which is, so to speak, crystallized the will of the founder, a personality represented by the administrator, trustee of the trust, nazir of the waqf, to the profit of its beneficiaries. In what measure, under what conditions, are these different forms imposed on this will when it concerns an international subject? In speaking only of the French law, an establishment destined to operate upon the territory ought necessarily to be constituted and administered conformably to the domestic law. It could not be considered as foreign under the pretext that it is directed by a committee that sits abroad. Perhaps, for example, a trust established in London for carrying on in Paris a public library of English books or a British free hospital. In France, at least, this establishment could only be French. It ought to be organized and administered according to the forms, the conditions, and the rules of the French law. This strictly territorial character of the provisions relative to artificial persons with an ideal object reduces singularly the practical interest of which the determination or the change of their nationality is susceptible. A company can very well, we have seen, possess establishments and even its principal center of exploitation upon the territory of a state of which it is not the subject. In like case the branch of the association or establishment of the endowment fixed upon the territory of this state will be, on the contrary, considered purely and simply as domestic in the limits of this territory. Let us add, in these limits only, upon a third territory, the judicial rule which determines the nationality of the imaginary being by the consideration of its principal administrative seat will be applied, and the artificial person will enjoy, in all countries where it is fixed, one and the same nationality, one and the same statute, that of this general domicile, save, well understood, If the lien which binds the domestic branches of the association or of the cosmopolitan endowment is purely ideal, of such sort that they enjoy, respectively, a material organization absolutely distinct and independent, and thus constitute, judicially speaking, many endowments or distinct associations,